Buenos días público, audiencia que nos acompaña esta mañana. Buenos días, Jorge. Pues parte de la Academia Mexicana de Derecho Informático y de la Escuela de Derecho Digital, como saben, celebramos en mayo nuestros diálogos de Derecho Digital y en el transcurso de este mes que hemos estado presentes en diferentes conferencias, no podía faltar la relativa a telecomunicaciones. Me presento, soy Lorena Aragón, miembro de la Academia Mexicana de Derecho Informático, y presento a mi colega y amigo Jorge Moreno. ¿Cómo estás, Jorge?
Bien, Lore, siempre un gusto saludarte y bueno, con otra oportunidad de hablar de temas interesantes y hoy día muy emocionado porque creo que le estamos tratando de dar un giro a esto, a todos estos diálogos, tratando de ver qué está haciendo el mundo respecto a la legislación y la regulación en temas de Internet y derecho digital. Entonces, mil gracias y muy agradecido por la invitación, Lore.
Muy bien, vamos a presentar a nuestros dos ponentes que estamos hoy de fiesta, yo diría. Ellos nos conectamos al otro lado del mundo, Dani Preiskel y Xavier Prida. Y bueno, yo procedo a presentar a Dani. Dani es un abogado líder en Gran Bretaña y en Europa, básicamente, pero también ha hecho trabajos fuera del continente europeo, como Australia, como Latinoamérica. Daniel es abogado de la Universidad de Cambridge. Ha tenido por más de 25 años, ha sido líder en su despacho, el despacho que él fundó con su hermano, que es un despacho líder en la materia. Tiene como clientes operadores móviles, operadores virtuales móviles. En este sector en particular, Daniel es gran líder y especialista, que yo debo de conocer que todo lo que aprendí de operador móvil virtual ha sido gracias a Daniel. OTTs, neutralidad de la red, por supuesto, protección de datos personales, privacidad. Y hoy, thank you, Danny, for being with us and giving some time for today. I see that it's sunny London today.
Yeah, sun is coming.
Yeah.
Gracias,
So,
Lorena,
Jorge.
Me encanta trabajar con México, con ustedes. Es un placer. Tengo un poco de México en mi corazón.
Thank you.
También es muy interesante de parte del mercado de telecomunicaciones lo que está pasando en México.
Yes, thank you. Nosotros hemos tenido muchas pláticas sobre la red compartida, su evolución en el tiempo. Aquí Jorge, mi colega, ha hecho varios estudios sobre red compartida y críticas, pero sí, a pesar de la pandemia, de situaciones económicas que se han presentado en México, nuestro mercado se mueve. Colegas, por favor, a todos quienes están acompañando hoy hacemos la presentación en español, habrá una presentación en español, pero vamos a cambiar al idioma inglés en las pláticas con nuestros invitados. Gracias.
Gracias. Thank you.
Lore, si quieres, presento rápidamente a Xavier. Javier Prida es un abogado mexicano, que la verdad es un orgullo tenerlo. Él es un especialista en todo lo que es derecho de las telecomunicaciones y él es abogado por la Universidad Iberoamericana e hizo su máster en lo que es Media y Law en Queen Mary University en Londres. Trabaja hoy día en un despacho en Londres, es especialista en todo este tema. Y bueno, él empezará con una plática sobre lo que es el sistema legal para los abogados mexicanos. De ahí seguiremos una plática con Daniel y después tendremos algunas preguntas y respuestas sobre temas de interés, tomando como base las presentaciones y algunas inquietudes que tenemos los presentadores hoy día. Entonces, sin más preámbulo, agradecerles su presencia. Daniel, Javier, bienvenidos, gracias por estar con nosotros. Si quieres empezar, Javier, adelante.
Claro que sí, muchísimas gracias Jorge y Lorena y a la Academia por organizar esta plática. Ya como comentaba Lorena, trabajo en un despacho que se llama Preiskel & Co. Es un despacho basado aquí en Londres, Inglaterra, que precisamente especializa en los sectores de tecnología y telecomunicaciones. Ha sido independientemente reconocido y premiado por su experiencia y asesoría en cuestiones comerciales y regulatorias, incluyendo protección de datos, justo en estos sectores llamados, desde el mundo del sector TMT. Y bueno, la primera presentación, la primera parte de esta charla se va a enfocar en una descripción muy general de cómo está integrado el sistema legal en el Reino Unido. Vamos también a esbozar sobre las similitudes que tiene con el sistema legal mexicano. Vamos a también abordar un poco de tiempo en las diferencias que existen entre el sistema, los contratos americanos y los contratos británicos, que ahí sí que hay muchas diferencias, aunque no lo crean. Y bueno, simplemente concluir con el acuerdo bilateral que recientemente celebró el Reino Unido con México, pues para dar entrada a la materia y al marco regulatorio de las telecomunicaciones en el Reino Unido y en la Unión Europea. Entonces, sin mayor preámbulo, pues vamos a entrar en materia. A grandes rasgos, el sistema legal del Reino Unido aplica a las 4 naciones, ¿no? que comprenden la isla, que es Inglaterra, Gales, norte de Irlanda y Escocia. Cada una de estas, vamos a adelantarnos a la siguiente diapositiva, por favor. Una más, por favor. Muchas gracias. Bueno, entonces aplica a, como decía, Inglaterra, Gales, norte de Irlanda y Escocia, y cada una de estas naciones tiene cierta autonomía en cómo se regulan, ¿no? Por ejemplo, en Escocia la legislación en temas de propiedad y bienes se asemejaría más a las tradiciones civilistas, solo para ejemplificar, ¿no? Pero bueno, en esta presentación, que insisto, va a ser un repaso general, nos vamos a enfocar primordialmente en la ley inglesa y en Gales. La siguiente diapositiva, por favor. Bueno, como quizás sepan, una de las grandes, o el rasgo característico del sistema legal en el Reino Unido es que es common law. Esta palabra common law se origina durante el reinado del rey Enrique II, donde justo sucedió un fenómeno donde comienzan a reemplazarse las tradiciones locales por una nueva ley nacional que era common to all. Entonces, de ahí viene la palabra common law, y en esencia, una de las características fundamentales, como sabe la audiencia de este sistema legal, es que los precedentes judiciales son una de las fuentes primarias de la ley, y por ello los jueces tienen mayor digamos, autonomía y mayor poder de interpretar la ley, siempre dentro de ese margen de los precedentes judiciales. Siguiente diapositiva, por favor. Entonces, el Reino Unido, a diferencia de México, que México, como sabemos, tiene obviamente un solo documento donde está consagrada la Constitución. En el caso del Reino Unido no existe un documento único, sino que es un conjunto de estatutos escritos y otras fuentes nuestras como las convenciones constitucionales. Un ejemplo de una convención constitucional que en realidad son como costumbres, digamos, es, por ejemplo, un primer ministro que ha perdido la confianza de la Cámara de Comunes, que ahora vamos a describir con mayor detalle. Se espera que renuncie, ¿no? Si existe un gobierno alternativo que sí tenga la confianza. Entonces, aunque no está recogido en un documento por escrito, es una de las fuentes que integran, digamos, una de las costumbres que integran la Constitución. Siguiente diapositiva, por favor. Si bien a nivel constitucional aquí en el Reino Unido no hay una separación formal a nivel, insisto, constitución de los poderes, sí hay en la práctica, diapositiva por favor, en la práctica sí existen digamos, ramas, ¿no? Está el poder ejecutivo, que está integrado por el monarca, en este caso la reina Isabel, el primer ministro y otros miembros otros ministros del gobierno. Luego está el poder legislativo, también está integrado por el monarca, y es el parlamento, que está integrado por la House of Commons, o Cámara de los Comunes, y House of Lords o la Cámara de los Lords, ¿no? Más adelante entraremos en detalle. Y luego está obviamente el Poder Judicial, parecido a México. De nuevo está integrado por el monarca, los jueces calificados y los magistrados. Y como podrán ver, el monarca formalmente forma parte de cada de estas ramas del poder, pero realmente su competencia es más bien ceremonial. Es un protocolo, como saben, nuestros amigos en el Reino Unido se toman muy en serio, pero al final del día el gobierno y los poderes del gobierno los ejerce propiamente cada uno de los poderes, y luego la interacción de la reina es simplemente ceremonial, pero al final del día, para que una ley ya sea aprobada en el Parlamento, sí requiere del royal assent, como le llaman, ¿no? Y a su vez, el monarca es la cabeza de la rama judicial. La siguiente diapositiva, por favor. Como ya comentábamos, hay diversas fuentes que nacen del Parlamento, que está basado en Westminster, y a su vez está, una de las fuentes primarias, al ser common law, pues es propiamente los precedentes judiciales. Antes del Brexit, naturalmente, también una de las fuentes más importantes era la ley de la Unión Europea, y hay estatutos naturalmente locales, y la Convención de Derechos Humanos para todo lo que se refiere a esa materia. Ahora que sucedió Brexit, hay una serie de acuerdos de colaboración que se celebraron con la Unión Europea, que aplicaron una vez concluido el periodo de transición, que concluyó formalmente el 31 de diciembre de 2020, y versan sobre todo en materia de comercio y seguridad. Y ciertas legislaciones de la Unión Europea se han conservado y adaptado a la legislación inglesa, como lo es el caso de la protección de datos. Hoy por hoy, que se avecinan reformas importantes en la materia, es esencialmente una réplica del marco regulatorio de protección de datos de la Unión Europea. Y propiamente el funcionamiento del Parlamento, muy parecido no se puede equiparar al Congreso de la Unión en México, está compuesto, como ya habíamos comentado, de la House of Lords o la Cámara de los Lores, que podría equipararse a la Cámara de Senadores en México, y la House of Commons, que es la que podría equipararse a la Cámara de Diputados, y este es el órgano supremo y el único que puede aprobar leyes que apliquen a las 4 naciones que ya comentábamos. Siguiente diapositiva, por favor. La integración propiamente del Parlamento, y me voy muy rápido ya en esta parte, la Cámara de Comunes, que decíamos ya que se puede equiparar a la Cámara de Diputados, está integrada por 650 members of parliament, miembros del Parlamento. Estos se eligen por votación. El que tenga mayor número de votos va a representar una locación geográfica particular. Y mientras que la Cámara de los Lores está integrada por 800 lords, 600 de los cuales son propuestos por el primer ministro y aprobados por la reina, y el resto son diversas personalidades que tienen títulos aristocráticos, y también hay obispos de la Iglesia de Inglaterra, ¿no? Algo que sería impensable en México, pero aquí sigue habiendo cierta injerencia de la Iglesia de Inglaterra en el gobierno. Siguiente diapositiva, por favor. Ahora sí vamos porque parecería que, siendo tradiciones legales tan distintas como el law y el derecho civil que rige México, en la práctica, y lo puedo confirmar, yo llevo ya trabajando aquí en Inglaterra 4 años, y la realidad de las cosas es que en la práctica hay muchas similitudes. Por ejemplo, en tanto México como el Reino Unido son países que están abiertos siempre a inversión extranjera, facilitan y permiten que empresas extranjeras sean dueñas de empresas mexicanas y de sus subsidiarias. No hay control de capitales, por ejemplo. De nuevo, cualquier extranjero puede incorporar una empresa en ambos países. y los dos países tienen leyes de protección muy sólidas y una independencia judicial y del gremio legal que facilitan, de nuevo, la inversión extranjera. La siguiente diapositiva, por favor. Ya le comentaba al principio que iba también aprovechando el foro y naturalmente México siendo vecino de Estados Unidos, estamos todos los abogados internacionales en México expuestos con mucha frecuencia a los contratos americanos, y ahí, aunque no lo crean, aunque los dos países, Estados Unidos y el Reino Unido, son tradiciones legales del common law, a nivel contractual sí que hay muchísimas diferencias, y recuerdo yo una de las, bueno, hay diferencias en dos sentidos, ¿no? A nivel de redacción e incluso a nivel de interpretación. A nivel de redacción, anecdóticamente les platico que cuando me tocó revisar el primer contrato que me mandó Dani, me acuerdo que redacté la cláusula de liability con todas las mayúsculas y subrayado al estilo americano, y eso definitivamente no sucede de este mundo. La verdad es que, en contraste, los contratos aquí en Inglaterra son mucho más fáciles de leer, no tienen ese lenguaje tan pesado y tan a veces confuso que solemos ver en los contratos americanos, y también es tan fácil de leer incluso para no abogados. Entonces, son como, insisto, mucho más ligeros en ese sentido, aunque no entran obviamente a profundidad y tienen su propio formato, pero bueno, eso es una diferencia de estilo muy inmediatamente obvia. Ya a nivel de interpretación, comentábamos en las cláusulas de exclusión de responsabilidad, también hay qué se entiende por implícitamente excluido o no, difiere mucho de Estados Unidos a Reino Unido. En Estados Unidos tienes que expresamente mencionar cuáles exclusiones van a estar a nivel contractual, mientras que en el Reino Unido hay ciertas interpretaciones ya muy afines a estas cláusulas que se interpretan de otra forma de este lado del mundo. Y siguiente diapositiva, por favor. Y ya casi finalizando, nada más que pues subrayar una de las varios de los beneficios que hay, siguiente diapositiva, de incorporar una subsidiaria, una compañía del Reino Unido, que por cierto es un proceso a diferencia de México, que en otros países de Latinoamérica hay ciertos formalismos que se tienen que observar, como la comparecencia de notarios, etcétera. Aquí en Inglaterra puedes constituir una empresa en cuestión de horas. En cuestión de horas ya tienes completamente constituida, registrada tu compañía en la Companies House, que equivaldría al registro público de comercio en México. Y bueno, uno de los beneficios muy notorios es que las subsidiarias incorporadas en el Reino Unido gozan de autonomía, ¿no? Entonces no tienen que, para efectos prácticos, confiar los estados financieros con la empresa matriz, sea donde sea que se encuentre. Hay una protección, obviamente, de que los bienes de la empresa matriz no se ven afectados por la empresa o la subsidiaria británica, y la credibilidad que les representa a las compañías transnacionales frente a compañías británicas que naturalmente van a sentirse más cómodos contratando con una entidad registrada aquí en el Reino Unido, ¿no? Y por último, antes de entrar en materia del marco regulatorio de las telecomunicaciones en el Reino Unido y la Unión Europea, simplemente quería mencionar a rasgos generales los puntos, y por favor pasemos a la última diapositiva, sobre el nuevo acuerdo recientemente firmado entre México y el Reino Unido, que pues tiene como propósito justo aumentar el crecimiento económico tanto en México como en el Reino Unido. También tiene como propósito facilitar la coordinación política, y con un énfasis en todo lo relacionado al cambio climático, que obviamente es importante, y promueve pues mucho interés en inversiones en los sectores de financieros, energía, educación, manufactura, green finance, que también está ahorita muy popular, y tecnología y salud. Y ya por último, nada más para presentarles la última diapositiva, el equipo de abogados hispanohablantes en el despacho está Dani, que además de inglés y español habla otros 7 idiomas, es bastante prolífico en los idiomas, entiende perfecto español y también lo habla muy bien. Y bueno, claro, yo que soy mexicano, y José Saras, uno de los socios que es español, entonces trabajamos cotidianamente con documentos en español, con empresas no solo en España, sino a lo largo del gran continente latinoamericano, y creo que eso es parte del beneficio de estar en Londres, que es la capital del mundo, ¿no? Que gente de todas partes del mapa. Y bueno, pues muchas gracias por la atención. Le voy a pasar la palabra a mi socio Dani Preiskel, que va a entrar en materia del marco regulatorio de las telecomunicaciones aquí en la Unión Europea y en el Reino Unido.
Gracias, Javier. Lorena, ¿tiene cuestiones para Javier?
¿Algunas preguntas?
Preguntas.
Hasta ahora no. Creo que estás en silencio, Lorena, pero si no hay preguntas, entonces...
Thank you, Javier. No, una pregunta, más bien una observación. Yo nunca pensé que los contratos en los Estados Unidos, una amiga mía dice que siempre las cláusulas son lo que no es. Todo el lenguaje se versa en lo que no es a lo que sí es. Correcto, y entonces aquí, por lo que tú estás diciendo, son más sencillos y se plantea de lo que sí es, ¿verdad?
Correcto, justo así es la gran diferencia. Exacto, son páginas y páginas y páginas en los contratos americanos diciendo todo lo que no es y de pronto pasan por alto pues lo que es. Entonces aquí parten de la premisa contraria, más bien se detalla lo que es y se explica expresamente lo que no es. Y es mucho más fácil de leer y, insisto, como naturalmente muchos de nuestros clientes interactuamos con departamentos no necesariamente legales, ellos mismos se sienten ya muy cómodos leyendo este lenguaje que es en contraste mucho más accesible que el estilo americano.
Ok, gracias. ¿Tú, Jorge?
No, yo si quieres que Daniel presente, ya si estás de acuerdo, Javier, ya al final hacemos las preguntas ya en específico para, digamos, cerrar el tema, si estás de acuerdo.
Sí, correcto.
Perfecto.
Gracias por todo, pero me voy a seguir en inglés because I will spare you my Spanish today, such as we had a big firm party last night. So that's maybe not as good. So it gives me great pleasure to really give you an overview of really European and UK telecommunications legislation and regulatory approach. So hopefully there'll be some very useful lessons for the market. And, the Mexican telecoms market, as we all know, and I've been involved in Red Compartida myself, has a lot of challenge. So hopefully you can learn something from the European experience, and also where mistakes are still being made in Europe as well. It's not as if it's perfect, but I do think the European telecoms regulation has improved significantly of late. So if we can go to the next siguiente positiva, por favor. And so this is about our firm, but Javier has already mentioned that. So we go to the siguiente positiva, por favor. Okay, so this is what I'm going to really talk through very, very quickly today, and you can ask questions afterwards, but even after the talk. Very quickly, we'll give you a quick overview of some of the key concepts. ESG, which is a sort of new, environmental and social governance in the telecommunications sector, and it's become very, very popular, which we can talk about it. the new the European Electronic Communications Code. It's the new regulatory regime which really came into effect pretty much last year. It's the first major change in telecoms regulation in the European Union in 20 years, so we'll talk about that. And then we'll look at it from a perspective of mobile network operators and investing in 5G and broader, mobile connectivity. And then we'll be looking at, mobile consolidation, which is in fact mergers, because they want to merge because it's so expensive actually now for them in building out the networks. And then a little bit finally about roaming charges. But do please feel free to put in questions to the team, and I think probably Lorena will ask a few questions either during my presentation. Feel free to do that in the middle or at the end if we've got time. So if we move to the next slide, please. In fact, we can go straight to click through to two slides, please. Lorena, el siguiente positivo. Sí, perfecto. So ESG, a lot of people don't know really what it means. It's just really the sort of buzzword, doing the right thing. It kind of stands for environmental, social, and governance, and it's coming to telecoms in two main ways just in the last year, I would say. One is people have realized the need for broadband connectivity as part of what they call broader welfare, social welfare. Households need broadband access, and because of the pandemic, people need to be able to work from home and remotely. If you don't have internet connectivity, it does affect your livelihood, households' livelihood, what they can earn. It's become really important. So even at the GSMA, they've realized there's got to be what they call a move across the world for digital inclusion to get as many people connected to the internet. I think this is something obviously very important in Mexico, where you have millions of people still who are not connected to the internet. And, without that connection to the internet, they are going to feel excluded, and it is going to impact on them from a social and economical perspective without that. So hopefully there will be lessons learned that with regulation and investment in telecoms, we can help ensure that more Mexicans and people generally on the world who don't have internet access will be given access. And actually over time it's developing to actually giving them broadband, because an old-fashioned dial-up, those of us old enough to remember that noise when you dialed up to connect the internet. Imagine having to do that these days. How it will be bad. So, it's good to see the ESG and a real political will as well for digital inclusion. And just here, the mobile operators have committed to their what they call the humanitarian connectivity charter. It's almost, questioning whether it's a human right to have internet access. And that's something to be keeping an eye out. As for me, I have been a judge on probably the most prestigious telecoms industry awards for many years, the Capacity Carrier Awards. And this last year, for the first time, we had an ESG category. And it was an honor to be a judge. And actually, but there they went for carbon neutral. It was actually, the winner was a mega Chinese company building networks around the world who were actually managing to do it in a carbon neutral way. So you have on the one hand ESG, connecting people to the internet and connectivity. On the other hand, in telecoms, you've got it's beautiful to see commitments from companies building out networks to build them out in a carbon neutral way. So that's ESG. Now, on the next slide, Lorena, I'm going to be talking about the new electronic European Electronic Communications Code. it's the first major overhaul of telecoms legislation in Europe for 20 years. And I think we'll just go through to the next stage. I mean, the idea is that all the European member states will adopt telecoms laws which are consistent with this new background. And if we go to the next slide, we'll go to the objectives. So what does it want to achieve? They want to facilitate, make it easier for the rollout and investment into high capacity networks throughout Europe. So they want to encourage co-investment. Now, until the new laws, the previous laws from 2003 were really, I think they were drafted by competition and trust lawyers who thought that if we have antitrust, everything else will be fine. All we need to do is say antitrust laws will apply to telecoms and everything will be perfect. Everything will sort itself out. But I was a bit skeptical about that, and it seemed it hasn't really worked. You do need some specific relaxation of antitrust to allow for co-investment. And what they've realised now is that allowing mobile network operators and companies to collaborate, enter into joint ventures and network sharing if it's for the purpose of really building out high capacity networks. And so it's allowing joint ventures and even mergers which would have not been allowed under pure competition law grounds. So that's the real change at that end. Then there's more consumer protection to help them from increased prices. So that's been caps in terms of the core retail, what a consumer pays, but also what mobile and fixed termination rates, what's charged from the carriers to other carriers for termination. Because clearly you've got the wholesale charge, and if carrier, say Telefonica in Spain is charging 10, 15 euro cents for termination of call, and you can only you want to pass that on to the consumers. So they are regulated both at the wholesale level in terms of what they can charge and at the retail level. So that's really helped bring down call charges, costs to the consumers. And the roaming was horrendous. The roaming bills were absolutely horrendous in Europe, and actually when you go abroad they are still horrendous, absolutely horrific. For us as we weren't part of the European Union, when we used to go out of the European Union, use our mobile phones, we were absolutely shocked at the pricing for roaming, and I'm sure that's something that Mexicans also suffer when they go abroad. So that's all regulated from a consumer protection. Now, for many years, the mobile and the big telecoms carriers were really upset that the like Skype and WhatsApp in particular would avoid telecoms regulation. And they were lobbying for many years for the OTTs, over-the-top players, to be regulated. And there's obviously been a lot of lobbying, and under the new regulatory regime, if the OTTs are now brought in the definition, but only where it's real telephone replacement. So effectively, when there's calls to numbers, that's when effectively they'll be regulated, sort of internet service providers, etc. But the interesting thing is for the OTTs, it can also be beneficial because by being regulated and registered, they have access to numbers. Actually, getting access to mobile numbers can be very, very useful as well, especially for internet IoT devices. So, and they also brought in just more technically user-leave-it provision for spectrum. So when they have spectrum auctions, especially 5G, you've got lots of very high frequency being frequencies being auctioned off. At the moment, really nobody knows what they can do with them. So you've got the big mobile operators just buying them, sitting on them, and hoping that maybe one day they'll use them, but also to stop new market entrants. Ultimately, when we look at who's buying the spectrum, it's the current MNOs, and part of that is to stop new entrants being. And the idea is that if they don't use the spectrum, then potentially they could, forfeit it and offer to a new entrant. But generally speaking, the European Union has failed over the last, I would say, 20 years to introduce new major mobile network operators. The only one that has really survived is Hutchison, with operations in about 6 or so European countries. Very few of them are actually making any money. And in fact, the trend is now to consolidate further. So next slide, please. So I touched on this briefly. So, this is just important. Mobile operators are really suffering the cost of having to add 5G networks or even 4G networks. So there is a regulatory shift away from pure competition law to allow them to co-invest. Now, interestingly enough, there is a technical potential drawback in the current legislation, which hopefully you won't replicate in Mexico, because to facilitate network sharing for 5G, actually, you can only do 5G for part of it at the moment. You probably need to do 4G, 3G, and other elements as part of that network sharing. And currently, it's only really the very high capacity element that is effectively got that exemption from pure competition rules. But we'll see how it's implemented, and hopefully it'll be implemented with a bit of common sense. But it is the most important regulatory change in the European Union for some 20 years. Next slide, please. So again, what's challenging it? I said there was a famous, it's unconfirmed statement from, I think, Eric Schmidt, the CEO of Google at the time, when he had a meeting in France with the CEOs of the most important mobile network operators in the world, and he said, this is even in the 4G days, he said, hurry up and build your 4G network so that Google can make all the money. And that is part of the problem. The dumb pipe is very expensive, just building that. So only for Google, etc., to make all the money. So what are they looking at? They want everything that they can get from a regulatory perspective to allow them to invest and get exemptions from the pure competition law. And one of the issues we've got in Europe is the ban on Huawei, the issue, partial ban. From a security purpose, Huawei equipment is, I've been told to be very unreliable and insecure. And it's not just the Chinese that can actually hack into it and see what's going on. It's pretty much anyone who wants to can hack into that. That's what I've been told from a security point. So, but the mobile operators, the Huawei equipment is about 10%, they say, of the alternatives. So clearly, the mobile operators have a huge incentive to ensure that they can use Huawei equipment. So that's just an ongoing battle that will be fought out across in, pretty much every country that is looking to impose a ban on the use of Huawei or other Chinese equipment. So they're looking at that, the mobile operators, which will obviously reduce the cost of building out 5G. The consolidation also effectively consolidation to reduce competition and increase efficiencies. This is very important, and there's a lot of lobbying to allow mobile operators to effectively merge, actively reduce the number of mobile operators, in a country. I mean, the European mobile operators say, look, in every country there's somewhere between 3 and 4 mobile operators, but in the US you have about 3 or 4 mobile operators to cover about 300 million people. They're similar size to the Europe, but here we have so many. So that's the argument they use, and I'm going to be looking at that a little bit in more detail going forward. And yeah, we've mentioned the incentives for allowing anything to incentivize investment in high capacity networks should be encouraged. Mm-hmm. I'm going to get to the next slide on MNO, mobile network consolidation. Now, this is so Lorena, if you can go to the cost of the wild plan. I think I've spoken about it, so we can go to the next slide, actually. Mm-hmm. So MNO consolidation is very important. So what happened in the UK is that there was Block O2, which is owned by Telefonica, and 3 UK, which is the smallest operator owned by Hutchison, that they tried to merge, and it was blocked by the European Commission because that would have taken the UK number of MNOs from 4 to 3. Now, what that means is shareholder values of the mobile operators went down, because what happens of the value of a mobile operator, the most likely purchaser of a mobile operator is another mobile operator. So if they're banned, if the regulator bans them, the merger is happening, the value will go down because they're unlikely to be bought by a mobile operator in that market, which is the most likely option for them to get the highest value. So it reduces their value. You reduce value, it's much harder to cost of finance, etc. Goes up. So what was good was that merger block was appealed to the European Commission at the European Court of Justice at the first court, and it was overturned. The EUCJ, European Court of Justice, not the highest court, the European, said that decision by the Commission was wrong. So that opens the door to mergers, and that in effect increases their value. The European Commission are appealing that to the highest court, and so that will we shall see. And it's very interesting that merger will never take place. So even though the decision was overturned, and they said that merger should not be blocked, it was just too late for O2 and 3 to actually undergo their merger some years later after they pulled out. But the European Commission spent a lot of money on the appeal, and now, which they lost, now they're appealing again because the European Commission wants to block, mobile consolidation, mobile mergers. And clearly, it's something that everyone's thinking very carefully here, because if mobile mergers are made more easily, that increases the value of all the mobile operators in Europe in a big way. So that's why we're looking at the MNO consolidation very, very carefully. And my view is going forward is that there will be more MNO consolidation, even if this particular appeal is lost because of the new regulatory regime, trying to do everything to help consolidation, co-investment in 5G and high-capacity networks. So I think going forwards, that will be relaxed. And then the last, the next slide, Lorena, is about, you can move on to roaming charges. Yeah. So this is really just a UK element. Because of Brexit, we are no longer in the European Union, means the European Union laws don't technically apply to us. So this was very good news for the mobile operators, because they said, great, we can charge what we like to UK subscribers when they go to Europe. And I spoke to Ofcom many years ago. I said, this is what will happen. And they said, yeah, there's nothing we can do. So now, the operators, when you go to Europe, suddenly getting these high bills. And that's also at the wholesale level. So when UK tourists go to Spain looking for some sunshine, although we've got plenty of sunshine at the moment, Telefonica now charge a nice hefty premium to those UK. Well, they'll charge it to the UK mobile network operators at the wholesale level, and they'll pass on the cost to the UK customers. And the other element is that UK subscribers no longer benefit from what they call EU portability regulation. So we were able to go to Europe and watch our Netflix account, and most importantly, our football. So we watch the football through Sky or BT in the UK. We, under the EU portability regulation, we could, when we're in, say, France for a business meeting in the evening, we could, open the laptop and watch the football. That is all gone, and it's quite painful now, that we can't watch our content as if we're in the UK anymore. So that's just impacting us on the UK, but it's really just a kind of light touch thing to say that the UK position is now beginning to diverge a little bit from Europe. But on the flip side, the UK said that they can pick and choose the best bits from European relation, and that's I think that's a good thing, as Mexicans can, because when you look at what we have in the UK, and then that's great. So, Lorena, is there another slide? Yeah. So, I think overall, and this is hugely important, is the idea of relaxation of licensing. So the UK was the first one. So back in 2003, the UK decided, it's pretty much one of the only countries, along with a couple of Scandinavian countries, that if you were even an MVNO provider in the UK, or providing wholesale telecoms, retail to customers, you do not need a license. It's absolutely incredible. I mean, there are rules you have to follow, regulate you, but you do not have to apply for a license. Whereas, when other countries were charging a lot of money and still do. So the UK were the first ones. I mean, I spoke to very recently the Spanish telecoms regulator. They can believe that, Ofcom, the UK telecoms regulator, had no idea, had no contact details for the telecoms operators. In the UK, they don't have to register. But ultimately, it's incredibly effective in terms of making it a thriving telecommunications sector, because companies, especially, say, they have to spend money, get money and management time to get licensed. So in the UK, you only need the license if you're actually the principal owner and user of spectrum. But even if you're an MVNO, you can be like Virgin Media with millions of customers that don't know the difference between an MVNO such as Virgin and a Vodafone. You don't need a telecom license or anything. So it makes it very, very easy. Now, for Internet of Things, it's a real problem in Europe because you need to register, and effectively they call it registration, but in effect it's like a license. but so it's a real pain because clearly so many of the services are pan-European global, so to apply every country. And some of the countries are very bureaucratic. They need, all sorts of, forms which aren't designed for IoT and resellers. It's a real absolute pain. But since the EECC, other countries have become lighter, and actually quite a few services that you needed to register for, say in France or Germany, you no longer need to, but there are still a lot that you do need to register. But that is something that I would urge Mexico to relax, because otherwise it really makes it more difficult for companies providing new services if you have to register with the regulator. And what it does mean, unfortunately, is that it's bad news for lawyers, because you can't have lawyers charging to apply for telecoms licenses anymore. We lost that in the UK many years ago, whereas we also saw our colleagues across the world still making money, and it's very, very good to train up telecoms lawyers with those licenses. Depending on your perspective, it might be seen as a good thing that they don't need to spend money with lawyers for the telecoms licenses, or a bad thing, depending on your perspective. But that's the reality of where it's going, and something to bear in mind. But in the UK, you do not need to apply to Ofcom if you're providing a telecoms service, unless you're like the main mobile operator and you've got a few $1 billion to spare for some spectrum. So okay. I think on that note, I'll hand back in Mexico.
Okay, thank you, Danny. Thank you, Javier. A very extensive. We appreciate the overview of the presentation. We have some questions. I will begin with the questions, especially what would you mean? I heard that to talk about the policy, this new policy on spectrum regarding the use it or leave it, use it or leave it. My concern is what is the scope of this new rule? If that means that in certain time you don't exploit, or you don't apply this spectrum for the same time purposes authorized by the Ofcom, you have to return. How is the transition to return? Is this new regulation has been actually applied, so you can see the consequences of returning, or you renegotiate? We have in Mexico a case back in 10 years ago regarding, if Jorge, you may recall, Javier, you may recall, with MDS, it happened to have the 2.5 gigahertz bandwidth, and the authority needed to, to allocate it again for internet mobile. And it was a really problem with the authority, they claimed it was a expropriation, and it was, but actually they were not using that spectrum. They were using just very, very few blocks. So how this new policy or rule regarding the return of spectrum applies?
That's a good question. I think that it's a bit too early to tell, because it's really a principle that they've put in on a sort of pan-European regulation. What's related to it is that the mobile operators wanted licenses to be for a minimum of 25 years. And it was, in the end, it was set at 20 years. That cost them a lot more money, because it means 5 years earlier they're going to have to rebid and probably pay another few billion, for the cost of the spectrum that they've got. So they were really hit on that. And in essence, by shortening the license period, you have a chance for users to leave it because they have to pay for it. But there's also spectrum trading, and in practice, some of the companies that haven't been using it may sell that spectrum to other operators. But too early, unfortunately, to see how the use it or leave it provisions are going to work. But we'll keep an eye on it.
Okay, thank you, Jorge.
Perfect. First, thank you very much, Javier, Daniel, for the great explanation of all these things. I'm going to make a quick question regarding the OTT or the over-the-top services.
Mm-hmm.
First is, in the UK, the OTT services includes cloud computing and Internet of the Things. And the second thing is, do you believe, Javier, that in the privacy in the privacy issue, there is enough regulation in the UK to protect all the services that right now we are finding in the network, and Mexico could adapt the legislation in order to enforce the protection for the end users?
Yeah, I mean, there are a couple of questions. On the OTT, the rules were a lot less severe, I think, on the OTTs than the sort of, the big mobile operators wanted initially. And also now, because they've reduced slightly the regulatory burden, it's not as terrible to have to notify regulators if you're using. But in terms of Internet of Things, but it is still an administrative burden, it is problematic. And when I wrote an article to publish one of the books on the ECC, I said their biggest mistake was they didn't address Internet of Things. They just didn't address it. And a lot of the new Internet of Things applications would, because of this regulation, expanding to OTTs would catch them. So we actually arguing and found out strategies to portray the Internet of Things solutions in a way that doesn't need them to be registered. But it's very much, you have to present them as the sort of, the connectivity is just a sort of very tangential, not main part of the IoT service.
Okay.
But the default, really, they probably will get caught, which is a big mistake, and that should not happen in Mexico. But the way around it is for the regulators to agree with our approach that, if the connectivity is just like a method to achieve the service, then it shouldn't be regulated.
Exactly. Yeah, because we see when we're advising our clients specifically on the regulatory landscape across the globe, when client identifies and we help them identify all these administrative burdens, that really deters them, and they end up not choosing to operate in those jurisdictions. So I think, as Dan is saying, the American regulator could really learn from experience and try to lighten those, specifically regarding the IoT, because the connectivity, as he said, is so incidental that it doesn't really warrant a registration per se. And, so yeah, we definitely are of the idea that it should be softened, that red tape should be eliminated altogether. Mm-hmm. Yeah.
And the UK is, we think the leading major jurisdictions. For example, we advise one of the big German car manufacturers on their connected cars and things, and in the UK they don't need to be registered, but countries consider that they probably do need to be registered because the cars have SIM connectivity in them. Mm. But you then get an absurd situation where car manufacturers applying for a telecoms license doesn't know anything. Okay. So even though the connectivity is being provided by an underlying mobile operator, so I would urge Mexican to follow the UK example and not require the car manufacturers to register with the communications authority and have all the obligations which don't really make sense when you consider it in terms of a car.
Perfect.
Okay.
Javier, a quick question before the question of the audience. Javier, as a privacy lawyer, do you believe that Mexico is ready to be doing business and protect the information of the users and comply with the GDPR and other rules established in the UK and other nations? Or we have to work as a country, not only in the laws, but also in the authorities in order to be together and enforce these responsibilities?
That's a great question, and we've actually been constantly, increasingly seeing that applying the GDPR standard for multinationals as a kind of golden standard, regardless of the local regulations, is a good practice, because at the end of the day, as you all already know, the GDPR has a very wide reach of enforceability, and if you use that as the parameter, as things stand now, even here in the UK, where, you know, as a result of Brexit, they essentially replicated the GDPR and adapted it to local law. Yeah, it's a good standard, because at the end of the day, it's been evolving so much that you're usually very likely to be locally compliant if you follow the standards of the GDPR. That are usually, you know, way more. The threshold is larger than in many countries, and Mexico has a kind of hybrid approach to data protection, whereas because they kind of replicate the US standard, but it's also an ever-changing regulatory aspect. But yeah, to put it as a conclusion, I think it's a good idea to use GDPR as a kind of standard to any multinationals' data protection activities.
Okay.
Thank you, Javier. Lorena, do you want to read the question of the audience?
Yeah. Oscar from the audience says, among the most recent telecommunication activities, which one do you consider requires more or better regulation? I mean, in general terms.
I think, as I mentioned, it's a good question. Regulation of Internet of Things, IoT.
Internet of Things.
You know, ultimately, I think that if there's a SIM card being provided by a regulated mobile network operator inside, then the company providing the device should not fall under the Telecom regulation. So the cars, or if you put a SIM card in a watch or laptop, we don't think that the laptop provider of hardware should be regulated.
Okay.
But it could well be, because a lot of regulators will actually, and they have a valid reason. They say, look, if you buy a laptop and you've got connectivity, you're buying it because it's connected to the internet. You're buying it for broadband. You don't know which mobile operator has the SIM inside. So your contract is only with the computer, the company that brought the computer, the shop even. You just don't know. So, that's why regulators take the view that if there's not a direct contract between the consumer and the mobile operator, then it should be the hardware provider that is the telecoms operator and needs to be regulated. But that should be avoided, in my view. So that's what I would change.
Thank you.
As the UK has done. Well, the UK has needed to do it because you don't need to actually register in the UK. So the other way is you just say no need to register, which gets you out of a lot of issues.
Okay, thank you. Jorge, you may have another question.
No, I think that we are running out of time. Unfortunately, I think that we have a lot of issues to talk with Daniel and Javier. It's very interesting to know this point of view, and I think that Mexico is in the right path in order to take a chance and make some changes to the relation in order to adapt to the technology and the new digital era. But again, thank you very much, Javier, Daniel. Lore, ¿quieres cerrar con una pregunta rápido o quiere o no sé si?
No, I will. No. I will also thank you. I appreciate, we at the Academia appreciate your time. As Jorge said, there is a universe of topics we can talk about. And thank you very much. It was much extensive, interesting the talk. Thank you. I don't know if you want to close with something, Danny, Javier, with something else.
Bueno, muchas gracias otra vez por la oportunidad. Ha sido un placer platicar de la experiencia de un abogado mexicano aquí en Inglaterra y, como decía Dani, aprender de cómo han atinado y errado en el marco regulatorio de este lado del mundo para que México adopte las mejores prácticas y siempre con miras a hacer atractiva la inversión en México, ¿no? Que es un mercado, ya decía Dani desde el principio, obviamente muy interesante, precisamente en este sector y pues al final del día las regulaciones no deberían de interferir en todo este potencial que tiene nuestro gran país. Y pues muchas gracias otra vez por la invitación.
Gracias. Dani.
Sí, igualmente, muchas gracias por la invitación. Está muy interesante verme. Estar contento de trabajar un poco más con México.
Yeah, we hope so.
Así es.
Yeah,
así es. Eso es lo que queremos y necesitamos, Dani.
Sí, inversión.
Sí.
Y con el nuevo tratado.
But really, just so that you know, from a telecommunications perspective, it's so interesting. You know, obviously, Mexico-US telecoms traffic is probably, I think it's the largest market for international minutes, but Red Compartida is also, I think, the most interesting telecoms infrastructure project that we've seen in the world, for better or for worse, but it's been incredibly interesting. So the whole world of lawyers have had a very, very keen interest in Mexican telecom regulation because of Red Compartida.
Thank you. Thank you for your time.
Esperemos que sea la primera de muchas pláticas con ustedes.
Gracias.
Gracias.
Gracias, que tengan buen día por allá.
Igualmente, chao, Sony London.
Okay,
chao. Bye.